where we are in terms of the tape and when that will come up. Obviously, investigator needs something longer than an hour. Don't know exactly how much longer it will be. Who is your next witness?
My next witness will be Amy Seward from FDLE.
How long do you anticipate your direct examination of her?
Probably close to 45 minutes.
In order to fully develop the parties' arguments on the motion, sorry, I didn't realize Mr. Locke wasn't here. I think we need to build that into our lunch break, and I don't think it'll come up until cross-examination of your FDLE expert, and I don't anticipate getting to that before lunch.
Okay. As long as I'm permitted to maybe reopen on direct based upon your rulings, whatever they may be.
Well, we may, I mean, we still have cross-examination to go. I don't know how much longer.
That's true.
I mean, I see us
before the horse, yeah.
And I don't care if you say you tender the witness, you don't have to say that. You can just say this may be a good stopping point, Judge.
Okay.
And we take our lunch break, whether that's 5 of, 10 of,
Okay.
10 after, and then we can deal with the motion without impinging on the jury's time.
Okay. Very good.
I've reviewed the tape now, and I have my outline for a determined questions I want to hear and information I want to hear and arguments before making a determination, but that's going to take more than 5 minutes, so I don't want to do that now.
Yes, ma'am.
And I think we can do it at the lunch break without holding up anybody.
Agreed.
Okay. And Mr. Ballerino, is Mr. Mott arguing that motion?
Yeah, and that's probably, he thought we were gonna do it when we got back, so I think I'll go down and get him and tell him that we're not gonna do it right now, we're gonna do it at the lunch break.
Whatever you prefer. We have 5 more minutes before the jury's due back. I just want to make sure.
I'll run down there and get him. There he is.
There you are.
Mr. Mott, and I apologize, I started doing this before I realized you weren't here, and I assumed that you were doing the argument based upon your prior comments.
Yes,
We're
sir.
not going to address it until the lunch break. We determined based on scheduling that we won't get to the cross-examination aspect of the FDLE expert until after lunch. So I've advised Mr. Will to let me know when he's at the end of his direct without saying that, to just say this is a good time for the lunch break. And then we will argue the motion so that we're not impinging on the jury's time. I know it's going to take more than 5 minutes.
Yes, ma'am.
Did I see you come in with some case law?
Yes, Your Honor, I haven't completely reviewed it, but I will
Okay,
provide
all right.
it to,
I was just going to say, when you're ready, you can give it to me for pre-review. But I have now reviewed the tape.
and I'll go ahead and just provide these cases.
There, at least one's a civil case, actually, I think both are civil cases. I
Several.
think the evidence code applies to both civil.
I would agree.
And they're distinguishable in certain respects. I don't think that either one necessarily involves a video, but the concepts to be argued. The cases are relevant to that.
Go ahead and take roll. I know it's a few minutes early, but here. it under personal items and come directly back out to the straight box. Jury. Jury. Jury may be seated. Everyone else may be seated. Mr. Norris, you may continue with your process.
Investigator Dewey, I'm going to backtrack for just one moment. All the yellow markers over there on the street area there, are those all shell casings, or were, I know your little yellow markers that you put out on the street, some of those were something other than shell casings, right?
Yes, that's correct. Some of those were allotted, some various other items, but all those depicted there are for the shell casing.
So those are the shell casings, and when you're looking at the scene photograph, and I don't remember exactly where it was, but there are other things in there. For instance, I believe there's a couple of cigarette butts that are in there.
Cigarette butts, a button, there's some chicken wing and
Yeah.
beer bottle.
Okay. All right. In reference to the shotgun again, the shell that was not found, I believe you testified on direct examination that perhaps one of the reasons why you may not have found the shell casings that were fired up at number 9 Aspen Street, because there's a possibility that someone could have stepped on them and put them into the dirt. Is that correct?
That is a possibility.
Well, that's what you said, I believe.
Yes, it's
Okay.
possible.
All right, so isn't it also possible that someone could have stepped on the brass end of the shotgun shell and could have pushed that into the dirt?
It's possible, not as likely, because the plastic gives a bit.
You arrived at the scene at 8 o'clock. By the time you got there, officers had already been on the scene for several hours. Do you have any idea how much traffic there may or may not have been up and down that road?
I have no clue on that point.
All right, let's talk about the difference between the sound of a shotgun, the sound of a rifle, and the sound of a 9mm. I believe that you previously testified that to a trained ear, they might know the difference between those. But to an untrained ear, they might not. Does that basically sum it up?
Yes, it does.
All right. So, in this particular case, witnesses have testified that they, in fact, based on their experience, know the difference between the two. Would that have any impact in the case, knowing the difference between the sounds of the gun?
If they're pretty sure of it, they,
What about a witness that is 8 to 10 feet away who not only heard the sound of the gun?
Objection. Calls for speculation, calls for this witness to make a credibility determination as to the testimony of another witness.
Do you wish to be heard any further, Mr. Lawrence?
Since he's an expert.
Do you wish to be heard any further? I want to excuse the jury.
Oh, yes,
as we
ma'am.
have argument. All right, jury, we'll need to go back into the jury room for argument. Claire, you may respond. Everyone else may be seated.
The expert witnesses are allowed to formulate their opinions based upon a number of different things, including hearsay, including the facts of other witnesses that have testified in case if you put that to them in the form of a hypothetical. In this particular case, the witness that I'm referring to in this case said that, one, they were 8 to 10 feet away, that based upon their experience, they knew the difference between a shotgun blast, a rifle, and a 9mm, and in fact, they saw it. My question to him is, taking into consideration all of those things, is that something that he should take into consideration? I think it's a perfectly logical and acceptable question to an expert.
Now that you know the full question, do you still maintain your objection?
And additionally, relevance.
Any further argument? Mr. Valverino?
No, I think it's all been argued.
I'll overrule the objection as long as the question is in the manner in which it was posed and not asking him if the witness was an expert, trained ear, etc. Just whether or not in the situation of being 8 feet away, knowing the difference. So it needs to be more in the form of a hypothetical. It started off sounding like it was more than a hypothetical and more like a asking for a commentary on that witness's credibility.
I'm not asking for that.
Right? So as long as the question is in concordance with what you proposed, the objection's overruled. That doesn't mean you can't object.
After thinking a little bit more, I also object on the grounds of improper bolstering.
And again, as long as he's not asking to comment on whether or not that witness could have, did, or would see or hear what he said, saw and heard, then I don't find that it would bolster the credibility. But again, it's got to be a very tight question as to the way that it's framed. And the way that Mr. Lawrence framed it to the court is acceptable, but if it goes beyond that scope, it may not be.
I've brought the same sort of thing up on a number of guys. Never asked him to tell me whether or not that person was telling the truth or not. I would not do that.
No, and I know you wouldn't in that pedantic of a term. However, there are ways that you could get the same point across. And again, the question you phrased doesn't do that. But if it goes beyond that scope, it may be further grounds for objection. So any further objections may be appropriate. All right? All right, we can bring the jury back in. Jury. gentlemen, I overruled the last objection. Mr. Lawrence will continue with his questioning.
Investigator DeWeese, if you were to take into consideration the following factors, that a witness standing 8 to 10 feet away from a shot being fired by what the witness says is a shotgun, and that witness also testifying that he knows the difference between the shots from a shotgun and the shots from a rifle and a 9mm, and that witness not only heard the shotgun, but he also saw the shotgun being fired. After taking into consideration each of those factors, does that affect your opinion about whether or not the shotgun was fired?
Again, sir, I have to go on the facts, what I'm looking for. I'm going to search just as thorough either way. And again, I don't know what this witness's, again, true expertise is. You know, what they claim versus what they are. I can't vouch to that.
There is no, strike that question. Referring once again to the diagram that is to your right, in the upper left-hand corner of the garage, there is what appears to me to be a shotgun that is drawn there on the floor. Do you see that?
Yes, sir, I do.
Is there any forensic evidence in this case that establishes how that shotgun got there?
Whether it was dropped, whether it was thrown, I cannot say.
Whether it was moved by somebody else?
It certainly should not have been, but before I got there, I cannot testify for it.
Over, I'm having a hard time seeing it, but I believe up in the middle part of the same diagram, there appears to be a couple there. Those two things right there, what are those?
There's the head of again, a DeWalt work-type flashlight, and then there's the battery over here of that same, the powers flashlight, which was broken apart.
Any forensic evidence on how those two pieces ended up there?
No, sir. All I can say is I looked closely at it. I was curious and wanted to determine whether or not gunfire had hit the light and or the battery, and certainly did not appear. So most likely dropped.
But no evidence one way or the other?
No, sir.
As a matter of fact, is there any evidence forensically that the person that is depicted in our artwork was in fact carrying that particular flashlight?
I have no direct forensic evidence of that, no, sir.
As a matter of fact, we don't even have any direct forensic evidence, do we not, that the person laying there was carrying that shotgun?
Just what I've been advised by my investigators.
So just because we might have a lack of forensic evidence as to a particular point of evidence does not mean that witness testimony is not valid, does it?
No, sir.
As a matter of fact, forensically speaking, you have absolutely no evidence that Brian Leverett ever even went to number 9 Aspen Street that night, do you?
No, sir.
Or at any time?
No, sir.
So the lack of forensic evidence as to that particular point really isn't relevant, is it? Because witnesses can testify to that, right?
Well, simply, again, I don't know what all the witnesses testified to, but I have no forensic evidence that he was there.
And you have no forensic evidence about the 3 warning shots being fired up there, do you? And the fact that you don't have any forensic evidence to that does not mean that they weren't fired.
That's certainly a possibility they were fired.
You don't have any forensic evidence that there was a fight out in front of number 9 Aspen Street that night, do you?
I knew there was something that caused bloodshed in the street.
You know, I'm not talking about the street, I'm talking about the yard, and maybe I phrased the question wrong. There's no forensic evidence to that effect, is there?
No, sir, not in the yard.
But that doesn't mean there wasn't a fight there, does it?
That's correct.
Forensically, you have told us you have no evidence that the shotgun was fired. Is that correct? Forensically, you've told us you don't have, there's no evidence that the shotgun was fired.
That is correct. And again, a lot of things you mentioned, like swapping the barrel and things of that nature, again, I cannot and will not do that at the scene at my level, because I owe it to the prosecution and the defense that this evidence remains neutral. I cannot alter it in any way. So again, I'm very limited to, as far as that respect, what I can do at a scene with a gun. I'm not going to alter it in any way.
But despite the fact that there is no forensic evidence that, from your perspective, that shows that that shotgun was not fired, does not mean that it wasn't fired, does it?
Again, in my opinion, what I saw on the barrel, the fiber, dust in it, I don't feel it was fired.
Forensically, if there's no gunshot residue on the hands of a person, doesn't mean that that person didn't fire a gun, does it?
It's certainly possible they did fire a gun.
Forensically, you have no evidence that a shotgun shell was fired, but that does not mean that that shell was not fired, does it?
Could you rephrase the question or repeat it, please?
Forensically, you did not find a shotgun shell.
No, sir.
That does not mean that it wasn't fired.
Again, I can't say, and it's my opinion, I can't say that that gun was fired. It's appeared to me it was not fired.
Each of the things that I just got through asking you about were independently witnessed by other witnesses. You would concur with me, would you not, that forensic evidence and eyewitness testimony need to go hand in hand whenever you are looking to resolve a crime scene?
They should go hand in hand, but I also know that physical evidence, unless you misinterpret it or fail to find it, that it is truth that stands on its own versus sometimes witnesses.
Certainly, forensic evidence can be a very useful tool, can it not?
Sure.
But would you agree with me that witnesses can be a useful tool as well?
Absolutely.
Your Honor, that's all my questions.
Counsel for Defendant Ray Greenlaw, have any questions?
A few, Your Honor, thank you.
Good morning, Investigator Ruiz.
Morning, sir.
Okay, just to start off here, and I think Mr. Lawrence made most of the points, so this should be pretty quick, but in Mr. Will's direct of you, Mr. Will asked you a question. I believe the question was, well, let me back up. When you first respond to the scene, you see the blood in the kitchen at 13 Aspen Street, correct?
Yes, sir.
And you follow it out onto the patio.
Yes, sir.
And then there's some papers out back that you also follow the blood.
Yes, sir.
And those are all hard surfaces where you're finding this blood, correct? And Mr. Will said, based on this trail, were you able to determine the origin of the blood, essentially, I think was the question, right? And I believe you responded something to the effect of, well, based on the path around the house, you found blood in the gutter in front of 9 Aspen Street.
That's correct. That would be the furthest point from the house where the victim, the bleeding victim, ended up being his location where he was treated and taken out by ambulance from that point. The furthest point that I can track that to is right in front of number 9 Aspen.
Okay. And so, and that trail in part is based on the blood recovered from the fence as well in the backyard area, right?
There was some blood on the fence, yes, sir.
Okay. And so all of these areas where you're seeing the blood is all hard surfaces, correct?
Yes, there was some on the grass, again, which led a little ways off the roadway there.
Okay, and it led a little off the roadway between,
Between 9 and 13.
between 9 and 13?
Yes.
Okay, and was that between 9 and 11? Or
Yeah,
thir-
between
11 and 13?
I'm sorry, between 9 and 11. I'm sorry. Excuse me, 13 and 11.
13 and 11.
Yes.
So, in this area somewhere.
I believe the blood on the grass. I don't hear. I may stand up.
Behind the street, in this area
Honestly, I need to look at my photos again, but I think in this area right here.
somewhere. Did you take a picture of that?
I did, yes.
Yeah. And that was just a small amount of blood that you...
Yes, very small amount.
Okay. The point being, you showed up that day and started your investigation around 8 in the morning, right?
Yes, sir.
And by the time that you got over to 9, it was 4:30, 5 o'clock in the afternoon.
Yes, sir, late in the afternoon.
And it had been raining steady for hours in between that time, correct?
Yes, seemed like at least a few hours in the morning. It rained by the time I was, it seemed like around noon, it was clearing up.
And so I think you had also testified that, when you're dealing with grass and dirt and stuff, the blood's basically more likely to wash away where you won't see it.
Absolutely, you have a porous surface there that it can soak into.
And so when you answer the question, Mr. Will's question of the origin of the blood, that's just the first spot that you were able to see blood on that hard surface, right? You're not saying necessarily that that's where the machete incident took place.
That will be a fair statement.
Okay. And just to recap, I think Mr. Lawrence hit on this quite extensively, but you wouldn't disagree with a witness that said that the machete incident occurred up in that yard area in front of number 9 Aspen, would you?
With the rain, it's, I can't say.
So you wouldn't disagree with the witness?
I can't disagree with it.
Now, no fingerprints were taken off the shotgun, right?
Not to my recollection, I did not do any fingerprinting. I don't know if FDLE was asked to.
Okay.
I did not.
You didn't
I preserved it for fingerprints.
Okay. But you didn't take any fingerprints off?
Yes, sir.
Okay. You didn't send any fingerprints off to the tech unit to get?
Yes, sir, I did not.
And so you don't know who might have touched that gun other than, well, anybody, but especially other than Mr. Leverett, somebody else could have touched that shotgun as well.
That's possible.
No gunshot residue test was taken of Mr. Meadow, was there, to your knowledge?
Not that I'm aware of. I'm not even familiar who that is.
Now, you've been working with the sheriff's office since around 1990, is that right?
88 is when I started.
88, okay. And you went to police academy, right?
Yes, sir.
And, well, let me back up. You wrote one narrative supplement in this case, correct?
Yes, sir.
And what's the purpose of a narrative supplement?
Purpose of the narrative supplement is to document what I have done in the case.
Okay.
What I saw.
And so you were trained, it's basically a police report essentially, isn't it?
That's exactly what it is.
Okay. And you were trained in police academy, and over the years you understand the importance of putting everything that's important in the case in a police report, correct?
Yes, sir.
Okay. Now, nowhere in your report, well, not only is it important to put stuff that you do find in the report, but it's also important to put stuff that you don't find in the report if it's relevant to the investigation, correct?
That would be correct, yet there's, again, you have to limit it to a point of what you have at that, at that point.
I understand. Your narrative supplement, I believe, was finalized in January 24th of 2012, correct?
I believe so, yes, sir.
So roughly 3-4 months after the incident.
Yes, sir.
And basically at that time, you go through all of your notes and everything else and determine what important things you're going to put in that report, correct?
Yes, sir.
Okay. And so in that report that you wrote, which was 2 days before you gave a deposition, correct?
That's probably the final time when I finished up the report. A lot of times may have started the day after the incident, but we'll,
Well, in that report, you noted, for example, that a white hat was found on the back porch area, I think.
Yes.
Okay. In fact, you even noted that there was a sandal found out in the yard in front of number 9 Aspen Street.
Yes.
Is that correct? And as far as you know, that sandal had nothing to do with the case whatsoever, right?
No clue what it's doing there.
But you're putting that in there in order to be thorough and accurate and complete in your report.
Yes.
Okay. And in that report, nowhere in that report, well, let me ask you this. Do you think that it's important that you found dust and debris in the barrel of a shotgun in a shooting case?
Again, it did become important.
Okay. Well, you're at the scene of a person who's been shot dead, and there's a shotgun, so anything having to do with that gun would probably be important, wouldn't it?
Absolutely.
Okay. And so, the fact that you found, or your testimony is that you found the dust and debris in the barrel of the gun is obviously important.
Yes, sir.
And yet, and the fact that you didn't see any of that little brown dirt that you talked about after a gun's been fired. I think you testified to that on direct.
Well, what I would expect to find, to clarify that, what I expect to find is not find the dust, but just find those unburned. There may have actually been some in it, but I saw this in addition to the dust and other debris in there, which led me to believe the gun had not been fired.
So you did find the little brown.
There was some pieces of debris in there, yes, but
And that's the stuff that's consistent with firing a gun or not?
certainly could be. I did not, again, I'm not going to put a swab down the barrel to find out exactly what it is.
Okay. Well, the point is, Investigator DeWeese, that despite your training and experience in 22 years and the multiple crime scene investigations that you've conducted, you've now come to investigate a shooting, and there's a gun, and you have 3 months, and you write a report, and you know how important it is to put all of the material evidence in the report and stuff that you aren't even sure if it's important or not, including the brown sandal, and yet nowhere in your report do you note the dust in the barrel of that gun, do you?
And it's in my notes, and I know I did it.
Okay, but in your supplement, nowhere in that police report did you mention anything about the dust or dirt or anything in the barrel of that gun?
I do, sir, not my report, no, sir.
May I have a moment, Your Honor?
You may.
Investigator Luis, is there a limit to how much you can write in a police report?
Yes, there really is, because it could become so full of things that really, aren't relevant in the moment, or, just makes it very difficult to read. I could write about the surface of the roadway here, about, many things that I remember in my notes, but yet also in my photographs. So that is in a report in itself, the photographs.
And in fact, the reason that you don't put everything in your report is because it can often be too much to deal with.
Absolutely.
And that's why they take depositions in criminal cases.
Yes, it is.
And these guys took a deposition of you, right?
Yes, they did.
Just 2 days after the report was finalized?
Yes, sir.
But while we're talking about your report, let's talk about the 29 pages of paperwork that you completed for the report. That's a lot of paperwork, right, sir? Is there any doubt that these gentlemen that have talked to you for the last hour about the dust and debris in the shotgun shell and the shotgun barrel, is there any doubt that somehow they failed to know about that? Or if they knew enough to talk with you about it for an hour,
Yes,
they obviously knew about it, right?
Yes, they did.
A little while ago, you mentioned to Mr. Lawrence an interesting thing about your job, and I'd like to go back and talk about it with you for a few minutes. It caught my attention. I think it probably caught other people's. You work for Volusia County Sheriff's Office.
That's correct.
You're a sworn law enforcement officer.
Yes, sir.
But as a crime scene investigator, you actually work for both the state and the defense, right?
Absolutely. Absolutely.
And why is your job to work for both the state and defense at a crime scene?
My job is to be neutral, to collect the evidence and let the evidence stand, and to preserve it the best I can, document it, keep it safe, and that way that it's of value.
Right. The jury is put into the jury room. Everyone else may be seated. Faces to your judge.
Probably got a little bit too far, but it's our position that this is probably proper bolstering. So, you just feel it's improper line of questioning that should not be allowed.
Any further argument on that point, Counselor Wayne Greenlaw? Mr. Will?
Judge, I don't believe it's improper bolstering. I think that the witness is permitted to answer the line of questioning. Then it will be resolved in the following conversation, that his job is to collect and preserve all evidence in the case, and that he is subject to scrutiny, both from the state and the defense, throughout the course of that job. And that if he does anything to tamper with the barrel of the shotgun, like run a swab down it, or load shotgun shells into it, then there are going to be complaints from everyone about tampering with the evidence. A question that is necessary because of the cross-examination brought about by the defense.
Well, cross-examination didn't address that. Investigator Luis's answer included that. So I think there is some room for an objection here. But Mr. Ballerino? Anything further?
Yes, Your Honor. In addition, as Mr. Mock pointed out, he works for the Volusia County Sheriff's Office, which is a law enforcement agency. He doesn't work for the defense or the defense attorneys, and so we just figured that we just believe that this line of questioning should stop, and at this point in time, it's improper bolstering of this witness's testimony.
Your Honor, may I just briefly throw in in response to the question I asked Investigator Luis, he said that his role was neutral, think that it is improper, but as long as he can answer the questions that he's neutral and that's his job, I don't see that that's an issue.
Right, I'll sustain the objection, allow you to rephrase the question so that the answer goes more toward neutrality rather than working for both the state and the defense.
And with the court being inclined to instruct the jury to disregard the question about, question and answer
No, I think it draws more attention to it.
That's
than-
the concern I have too also.
So now I'm not gonna give any kind of cautionary instruction to the jury. I'll just tell them that I sustain the objection and allow Mr. Will to rephrase the question. I think that's sufficient in the circumstances. All right, can I bring the jury back in? Jury. Jury may be seated. Everyone else may be seated. Ladies and gentlemen, I sustain the objection and have instructed Mr. Will to rephrase the question. You may do so at this time.
Thank you. Investigator DeWeese, I believe you testified that even though you're employed by a law enforcement agency, that you are really neutral in your crime scene examination.
That is correct, yes, sir.
And that you're the only person out there who's charged with the duties and responsibilities of collecting and preserving all of the evidence without respect to what it is.
That's right.
That at some point you have to release the crime scene back. And once this crime scene is released back into the public use, that there's no other opportunity to pick up any evidence.
That is right.
And so, given this neutral role as a crime scene investigator, what I want to talk with you about is some of the questions that you received earlier about this sniffing of the shotgun barrel and swabbing of the shotgun barrel. Let's start first with the sniffing of the shotgun barrel. Is that a widely accepted practice in your field?
No, not to my knowledge, because it can vary so much, you know, an odor.
Tell us about that.
You know, having fired many guns, you'll smell this is the cordite and the stuff that's found in the propellant powder residues and things. You get familiar with the smell. But then again, you know, to basically pick up this firearm and sniff the barrel of it, it could have been fired, you know, quite some time before and still have a bit of this odor to it. And again, I'm no odor expert. There's things you can confuse there. It's not something of scientific fact. And again, it's something that would have me putting an opinion in there I'm not comfortable with. Because again, my job is to collect it, to preserve it. Again, I saw the dust in it, but I'm not going to, in essence, do a sniff test on it. Maybe this is something for somebody more academic to do, but you know, I don't put much faith in it.
In fact, a lot of people in your field don't put much faith in it.
That's correct.
And if it has any traction at all in the field, it's from people who don't do field work, academics.
That's right.
So this sniffing of the barrel, so to speak, doesn't really pass the smell test. It's junk science.
Yes.
Let me talk with you about the swabbing of the barrel. Why is it that you wouldn't swab the barrel in the field?
Again, I'm not going to introduce anything extra or take anything away from this gun. I want it as pristine as possible. It's boxed up. That's why you don't see it. We don't present it to you in court with just a tag hanging on it. It's boxed up to keep it safe and to keep it as close to the way as it was found. And that's my objective. I'm not going to put anything down the barrel. I'm not going to load any shells into it or take it apart to check for plugs, because, again, I can alter it, and then that runs into problems, not only from, a veracity issue for me, it could become, because I've got many years with no problems with this, and I want to continue down that path.
In protocol, from the agency's perspective, and even in the field of forensics, is that you don't alter or tamper with the item.
No, I want there to be severe consequences for that.
And let's talk about what it is that you would find in the event that you did swab the barrel. Let's talk about what it is that you would stand to gain. If in this world where you were allowed to do whatever you wanted with the evidence, if you stuck a swab into the barrel of a shotgun that had been fired at any time in its history and not appropriately cleaned, would you expect to find gunshot residue down the barrel of the gun?
Yes, I would have basically put in a clean white swab and come out with a filthy one. Just be dirty.
And you've cleaned your own firearms.
Absolutely, and again, at the level of the Volusia County Sheriff's Office, we don't have lab equipment to test for gunshot residue or microscopes which will find traces of barium and stuff that's found, the chemicals found. So again, it would be a useless, a fruitless effort for me to do that in any respect.
But even if you swapped it, now, did you know that Brian Leverett was a hunter? The guy that died there in the garage? Did you know that he'd been using that shotgun for years?
I remember that when I run the ATF trace on the firearm, that it is, I think his father had bought it many, many years ago.
And if you swapped the barrel, would you expect to find gunshot residue whether or not it had been fired that morning?
Unless he's a very, very, very meticulous cleaner, I'm going to find something in it if I swab it out enough.
And so swabbing the barrel is really no indication as to whether it was fired that morning, is it?
No,
Nor is smelling it and sniffing it.
no.
And in fact, it's against the policy of the department and forensics to alter the evidence in any way.
That is correct.
Which is why you can't load shotgun shells into the weapon to determine how many it holds.
That's right.
And that's why you couldn't answer Mr. Lawrence's question
Yes.
all those months and years ago.
Yes, sir.
The next subject I want to talk with you about is forensic evidence. It's pretty difficult to remove all forensic evidence related to an event, right?
It is extremely difficult.
For instance, let's talk about this machete thing up in the front yard. The rain may have washed the blood into the grass,
Yes,
but you still found blood along the street, right?
that's correct.
You still found blood in the grassy area in between 11 and 13.
Yes,
You still found blood within your crime scene.
yes.
And so it's real hard to remove all traces of forensic evidence.
It's almost impossible.
Now, you didn't have any problem. Investigator, do you still have the scissors and the gloves?
Yes, sir, I do.
I'm going to ask you to pull out the 9mm casing again and lay it right there on the counter. I'm also going to ask you to cut open this and lay it and stand up both of the casings next to each other. And when I say this, reference it by number. The 9mm casing is coming out of Exhibit 15. or not. We were talking about how difficult it is to remove all forensic evidence from a crime scene,
Yes, sir.
or even to conceal all forensic evidence within a crime scene.
Yes, sir.
The 9mm, you found 13 of them out in the road.
Yes, I did.
And after you found those other 2 rounds up by number 9 of the 223, you took a metal detector and you swept the front yard of number 9 Aspen Street.
Yes, sir, I did.
Do you have any explanation for why it is that you never found those three small 9mm shell casings?
Well, there's various reasons, but I don't know.
If they had been mashed down in the mud,